I think this one is really neat because so you guys are all aware that there's a huge battle between Coinbase and the SEC, which is probably going to be partially informed now by the XRP versus SEC ruling that happened earlier this year, which we're all very excited about. But Coinbase is fighting the SEC, and I'm glad this is coming to court because this stuff needs to be aired out. The SEC has been hiding behind obscurity, and I want them to have to come to court and actually explain their case, which they have has not gone well for them because they've actually had to when they've actually had to defend themselves, they've done a pretty poor job of it. In the latest news in Coinbase, 6 legal experts, and these are law professors at some pretty big institutions like Yale, University of Chicago, UCLA, that kind of stuff, have filed amicus briefs in defense of Coinbase in the SEC's lawsuit against them. So why don't we look at this because they basically shred the whole investment contract. Okay, so this is from Meta Lawman. I think he's the guy that had a bunch of stuff about Gala too, but I could be wrong. I don't think that's him. I take it back. Anyway, he says SEC versus Coinbase, big update. 6 securities law scholars filed devastating amicus brief in support of Coinbase. Law professors from Yale, University of Chicago, UCLA, Fordham, Boston University, and Widener filed an amicus brief last night that absolutely shreds the SEC's investment contract theory. The amicus brief brilliantly traces the history of meaning of investment contract before, during, and after the passage of the Federal Securities Act of 1933. Here are the scholars' conclusions. By 1933, the state courts had converged around a standard for interpreting the term investment contract to mean a contractual arrangement that entitled an investor to a contractual share of the seller's later income, profits, or assets. After the Howey decision in 1946, the common thread for investment contracts remains that an investor must be promised, by virtue of his or her investment, an ongoing contractual interest in the income, profits, assets of the enterprise. Every investment contract identified by the Supreme Court involves a contractual undertaking to grant a surviving stake in the enterprise. Bottom line, in my opinion, this amicus brief delivers a coup de grace to the SEC's argument that crypto tokens trading on secondary markets are investment contracts. Yeah, how could it be? How could it be? It's crazy because it's on a secondary market. So David Weisberger asked, can Judge Torres cite this and other amici briefs as justifying good use of the plural of amicus, by the way. There's a guy who knows his Latin. Briefs as justifying a denial of the interlocutory appeal. Wait, that's a hard one to say. Or would it be better to allow it and cite their reasoning in her takedown of the Rakoff ruling? She can. That is the whole purpose of the briefs, to be filed. The law is the law. This is Stanislav. But then David Barrera says those law scholars grossly disregard the actual holding in Joyner, the first case in which the Supreme Court interpreted the definition of the term investment contract. Let's see what that said. In Joyner, the court found it unnecessary to determine whether or not the issuer had an obligation to drill enforceable by purchases, and therefore held an investment contract can exist even in the absence of obligations of the issuer enforceable by purchasers. Contrary to the scholar's assertion, the issuer in Joyner did not assume contractual undertakings to deliver future value reflecting the income, profits, or assets of a business, or to be more precise, the court found it unnecessary to determine whether any such contractual undertakings were present, because it could not find an investment contract regardless. The leasehold interest would appreciate if the issuer were successful in its oil exploration efforts, the same way tokens appreciate if the token's promoter is successful in developing and promoting the underlying protocol, product, or service. I don't think our main guy here ever responded. Well, they really get into it here, and that's we're not gonna dig into all that because there's a lot of stuff in there. But yeah, really interesting. It's definitely a case that we will be following, and I'm curious to see how it comes out.